Hello, I'm Melanie Risden with the Western Standard. Joining me right now is lawyer Jeff Rath, one of the lawyers that was involved in the Ingram versus the Alberta government, as well as the Chief Medical Officer of Health, Dr. Deena Hinshaw, a lawsuit that has been sort of ongoing for over a year now, and final arguments are in. So we are just going to get an update on those final arguments that have been submitted by Mr. Rath. Jeff, thanks for joining us.
Always a pleasure, Melanie. Thanks for having me.
So these final arguments, typically with final arguments, they would be sort of done in person in a courtroom, but with this particular situation, they were submitted in a written form. Am I assuming that you have received the written arguments on the other side, or defense on the other side?
No, we haven't yet.
You haven't?
Filed our written final argument. We'll receive theirs on the 10th of July, and then we'll have 2 weeks to respond or to reply. So that's where we're at in the proceedings right now. So all of the arguments will be finalized. The argument will be finalized. By roughly the 25th of July.
Okay. So let's talk about, first of all, let's set up the actual claim, the lawsuit. There was a number of claimants involved with this. Why don't you give us a bit of a summary on what this entailed?
Sure. Well, we're representing Rebecca Ingram. And of course, Ms. Ingram owned a business in Calgary that was completely devastated by Deena Hinshaw's order. She owned a fitness facility that was shut down, by order of Dr. Hinshaw, without anybody from Alberta Health ever determining that a single case of COVID had either been contracted or spread by Ms. Ingram's business, which is known as the Gym in Calgary. So from our perspective, the closure of her business was arbitrary. It was contrary to law. And both, that order and a number of other orders that Ms. Ingram was complaining about, if you recall the silly how many friends we could have orders, our submission is the masking orders themselves are ridiculous because they're not for a bona fide medical purpose. On the face of the orders themselves, they say you can wear a medical mask, a non-medical mask, or a face covering. So in other words, on the very face of the orders themselves, somebody could put a piece of mesh screen over their face that would completely comply, with these orders. And we say that, for these orders to be constitutional, they can't be arbitrary, they can't be capricious, they can't be silly. And our submission is that on the face of the masking orders themselves, were just downright silly. So, that's in part what we were arguing, we're arguing to the court. I mean, there's no porosity standard for the masks. And I mean, what we submitted in our written argument was, it's akin to bringing in an ordering somebody to put up a chain link fence to keep dust from blowing onto their neighbor's property. The orders were poorly drafted and were promulgated without any real medical necessity on the face of the orders themselves.
Mm-hmm. Now, you were working alongside with another lawyer, Leighton Gray, who was brought in with the Justice Center for Constitutional Freedoms, and working together on this case to support the claimants. Can you give me some of the main arguments? I know you've sort of mentioned sort of an umbrella of what the case was about. What were some of the main arguments that you guys had?
Sure, and to be clear, we were representing Rebecca Ingram, and my good friend Leighton Gray was representing Heights Baptist Church, Northside Baptist Church, Aaron Blacklaws, and Tori Tanner. So we were representing Rebecca Ingram, the named plaintiff, but Mr. Gray was representing through the JCCF a number of other named plaintiffs in this case. Okay. So from our perspective, we raised a number of arguments, both constitutional and non-constitutional. One of the things that caused us the most concern was that we found, in the court hearing through cross-examination from Deena Hinshaw, that the so-called Chief Medical Officer of Health orders weren't even her orders. She said the process was that she gave recommendations to Cabinet, and then Cabinet actually issued the orders. So what we're saying is that, that's ultra vires the scope of the act. The other thing that we're saying is that under the structure of the act, that if you want to close businesses, you can't do it by chief medical officer of health order. You've got to involve a judge in the process. Full compensation has to be paid. There's a number of processes set out in the Public Health Act that were not followed with regard to these orders. And in that regard, we say that the orders were all ultra vires the Public Health Act. The other thing that we were arguing was that unlike cases in other provinces and unlike other provinces, Alberta is unique in that Alberta has its own Bill of Rights that mirrors the Canadian, or not mirrors, that in essence replicates the Canadian Bill of Rights as it pertains to provincial legislation and provincial actions. Other provinces have human rights legislation, but none of them have a Bill of Rights in the same manner that Alberta has a Bill of Rights. So this is an issue that wasn't considered in Gateway in Manitoba and wasn't considered in other cases that were argued in British Columbia. And of course, what we say with regard to the Bill of Rights is that any legislation that is inconsistent with the Bill of Rights is a nullity. And in fact, the Public Health Act itself says that the Public Health Act is subordinate to the Bill of Rights, and that the Bill of Rights is paramount over the Public Health Act. So from our perspective, that causes a number of problems for the government of Alberta because they've acknowledged that there were various violations or infringements of the charter rights of the plaintiffs, which could then be saved by Section 1 of the Charter. But the problem for them is, or for the government is, that under the Bill of Rights, there is no Section 1. The only way that the government of Alberta can violate a right under the Alberta Bill of Rights is to actually pass legislation saying that the legislation will operate notwithstanding the Bill of Rights. So it has a notwithstanding provision in it. So there's a mechanism for the government to abrogate rights under the Bill of Rights, but they have to pass special legislation to do it. And notwithstanding the fact that they passed all kinds of COVID-related legislation, the government never took the step of declaring Public Health Act orders issued under the Public Health Act to operate notwithstanding the Bill of Rights. So we say that that is fatal to the Hinshaw orders, and that the Hinshaw orders themselves are therefore of no force and effect. The other thing that we say in that regard is that the court has an obligation under Canadian constitutional law, and we cited a case, I believe, called Campbell at the Ontario Court of Appeal, where that court found that it was trite law that you're supposed to decide matters in a non-constitutional manner rather than deciding them constitutionally, which means that the ultra vires argument that we've put forward, as well as the arguments under the Bill of Rights, have to be considered in advance of the charter arguments. And if the orders fall on the basis of those non-constitutional submissions, then the court doesn't even get into considering charter violations and getting into the whole Section 1 analysis, right? So from our perspective, we only get into Section 1 if those first two arguments don't succeed. So we're going to be very interested, obviously, in hearing what the court has to say in that regard.
Right. And so this has been going on for over a year. The proceedings have lasted quite long. What stood out to you the most throughout this process?
Well, there are a number of things, and I think we've spoken about them before. One of the things that really stood out to me is the lack of knowledge that the government has in and around the effect of these orders on the citizens of Alberta. It was really clear in cross-examining Dina Hinshaw. She knew that there were going to be very grave consequences from these orders that could include people committing suicide, business bankruptcies, the destruction of the economy of Alberta, etc. But nobody issuing these orders apparently had any real interest in determining how many suicides were would occur, how many suicides did occur, how many business bankruptcies would occur or did occur as a result of these orders. So to me, there's just this real solid lack of even curiosity on the part of government officials as to the lives that they were devastating in this province with very, very controversial, and I would say experimental public health measures around which there's a huge scientific debate swirling as to whether or not, the COVID orders themselves killed more people in Alberta than COVID. Certainly, in certain age cohorts, if you're looking at people under the age of 50, certainly there's a very strong argument to be made that the orders may have killed more people than COVID. And the lack of curiosity around this issue to me is really, really troubling. And another thing that came clear, and all of the witnesses admitted to it, they were taking all of their advice and guidance from this so-called scientific advisory panel. The scientific advisory panel had no trained psychologists or psychiatrists on the panel. Nobody was giving the government advice, apparently, with regard to the harm, the psychological harm being caused to citizens of this province by these intrusive orders, telling people how many friends they can have, locking people in their homes over Christmas, denying people the ability to worship in church, bankrupting businesses, et cetera, and no mechanisms were put in place, to make sure that these things didn't happen. In fact, we had evidence from one Alberta government witness who actually stated that the government intentionally structured the economic support programs to not provide full support to businesses. So there was a very deliberate and bloody-minded decision made at the governmental level to impose penalties or impose hardship on certain classes of businesses for the benefit of the public at large, or the alleged benefit of the public at large, while deliberately not fully compensating those people on behalf of the public. And to my way of thinking, this is something that has to be redressed on a going forward basis.
Absolutely. And I think, too, when you're discussing that, that the government has to produce some sort of a burden of proof or evidence that these measures were necessary when there has not been sufficient or as you're mentioning, barely any research or investigation into the outcome of the decisions, seems like an interesting part of that argument for sure.
Well, and it goes well beyond that. I mean, that's where I think we get into, the Section 1 arguments. I mean, we've got the government acknowledging that rights were infringed. I think Dr. Hinshaw even acknowledged that she knew that, that she was infringing the rights of citizens of this province, and under cross-examination. And one of the concerns that we have, obviously, is that where rights are infringed and where the government is invoking Section 1 of the Charter as a defense, or as they are in this case, and this is submitted in our written argument, there's an obligation on the part of the government to make sure that the infringements are as little as possible. So they had lots of other measures that they could have implemented that wouldn't have caused as much harm as the measures that they did, but there's no real evidence before the court that any real cost-benefit analysis was done of the measures, that they did apply, and that there's no evidence whatsoever that any thought was given to what they could do other than what they did, which from our perspective, fails the constitutional test under Section 1 of the Charter.
So with regard to your client, Miss Ingram, what is she seeking out of this? And then kind of the second part of that question would be, how is the result going to impact the other people that were participating in the proceedings, where we have the Heights Baptist Church and some other people mentioned as claimants?
This is a judicial review proceeding, so we're not seeking damages at this stage. But obviously what Ms. Ingram is seeking is declarations, that the orders were, ultra vires the government of Alberta because they offended the Bill of Rights. We were seeking declarations that the orders themselves, We're ultra vires the Public Health Act itself. We're seeking declarations that the orders that were issued and that are at issue in these proceedings, offended various sections of the Charter of Rights and Freedoms, from the standpoint of having the court declare all of these orders to have either been unlawful under the statute law of Alberta, or alternatively under the Charter of Rights and Freedoms of Alberta. So, this was obviously, a test case. It doesn't capture all of the orders that were issued by Dr. Hinshaw because of other rulings in this case. So, obviously, we'll be proceeding forward, whether it's by class action lawsuit with regard to the vaccine passport issue or otherwise. There are a number of orders that caused a lot of harm to people in this province that were not captured in this, in this proceeding, and that will remain live before the courts. So, in essence, this is the opening salvo, I think, in what's going to be an ongoing or opening battle, and what I perceive will be an ongoing war until such time as we're capable of electing somebody in this province that actually gives a damn about the rights of the citizens of this province and comes up with a way to fully compensate all of the people in this province that have been damaged by these hurtful orders of Dr. Hinshaw, orders of cabinet in effect, because Dr. Hinshaw, in fairness to her, repeatedly swore under oath that these were not her orders, that these were orders that came from cabinet. And, like Sergeant Schultz and Hogan's Heroes, she was just following orders, right? So, I guess that's what we're going to be dealing with on a going forward basis.
Now, if this is successful for your client and the others involved, what kind of precedent will this set? What ramifications will that have for, say, others who suffered through lockdowns and losing their business and things like that? What do you see coming?
Well, certainly, I think it's going to provide a huge amount of vindication to those of us that have been, of the view that, that these orders were improper throughout. One of the live issues that, that's remaining outstanding, and could well end up, being an issue for the Court of Appeal if the court doesn't reconsider it, is, an issue in and around that John Hopkins meta-analysis that came out, earlier this spring, that basically found that the non-pharmaceutical interventions of the types that were employed by Dr. Hinshaw actually cause more harm to society than good. We say that the court should have the full benefit of hindsight, and in cross-examining witnesses in a case, we should be able to put anything to them, to have them, have a witness, reconsider their position or admit that what they did was wrong. We weren't able to put certain pieces of evidence to the witness as a result of rulings of the learned trial justice, and those continue to be issues going forward. I mean, I think what we say in our written argument, is that, keeping up-to-date evidence as to the harms caused by the MPIs out of this proceeding, is artificial, and the court should have the full benefit of hindsight in judging the propriety of what these people did from the standpoint of both their competence and their credibility before the court. And we have Alberta Court of Appeal authority, on that point, that will become, germane as we move forward. I mean, what we say is, this is akin to Galileo challenging the findings of the Roman Catholic Church that he's a heretic for finding that the earth revolves around the sun rather than vice versa, and having Galileo being prevented from bringing forward expert witnesses that agree with his position on trial on the basis that the whole proceeding should be artificially limited to the information that was available to the decision maker at the time, the time the decision was made, to lock Galileo in his house for the rest of his life. We think it's a pretty, we don't think that that's a way that the court should be proceeding with regard to these matters, and that the court should have the full benefit of hindsight with regard to the most up-to-date scientific evidence as to the propriety of these matters.
Now, for instance, that Hopkins Oh, sorry. I'm just saying the Hopkins study, being that that was released in the spring, were you able to bring that forward as evidence at
Well, we
that
tried
stage, or
to
no?
have it put forward as evidence, and we were repeatedly told by the court that the evidence before the court was only going to be limited to evidence that was available to the decision maker prior to the orders having been issued. And
Right.
and we say that that's contrary to Alberta law and contrary to authority from the Alberta Court of Appeal. That's binding, on the court. And we've stated, in our in our final argument, that if the court doesn't reverse itself on this, on the Hopkins study, being available, that a mistrial may in fact be required on the constitutional issues, given the degree to which the standard practice of cross-examination has been departed from in this case.
So as you mentioned, you are waiting, it sounds like, till about, early to mid-July to hear back from the defendants. And then are you expecting to understand how this is going to be ruled on, did you say by the end of July?
The case will be fully in the hands of the learned justice, before the end of July. But
Okay.
obviously these are very complex issues. I honestly don't envy Madam Justice Romaine in having to deal with this case. She could be anywhere from 6 to 12, 3 to 6 to 12 months in coming to a decision with regard to this matter. I would, I'll leave it at that. I think at this stage, I mean, it's not. I gave up a long time ago guessing how long judges were going to take to render decisions, especially in cases as complex as this one.
Absolutely. All right. Well, thanks very much for a bit of a breakdown as to your final arguments for the case. And obviously we'll stay in touch with you. And when we have more information, or perhaps we get some information from the defendant side, we can touch base again and have a look at that. And then obviously we will await the ruling from the justice at the end of all of this.
All right. Well, thank you very much, Melanie. It's always a pleasure having the ability to chat with you. So thank you.
Thanks so much, Jeff.